Hi, I'm Gail Lee, and I'm the president of the board for Aging Advantage, and we're bringing you our series this week on preparing your legacy, your roadmap to planning, protection, and peace of mind. We're doing that in conjunction with Eamon Gantner and Capriano, Your Estate Matters LLC, and Amanda Wilson, one of our associate attorneys at Eamon Gantner and Capriano. This is a series that Aging Advantage, we try to do a lot of talks in the community with, we're a nonprofit agency and we're partially funded by donations and support from the City of St. Louis ARPA funds for the different households that have been affected and experiencing negative public health or economic impacts from COVID-19. We were established in 2017. We help the elders in the city, 60 and over, and 18-year-old and older disabled people to kind of manage all the different aspects of their life. And of course, when COVID came and had all these things, people are still having a lot of problems with social isolation and just a lot of economic things and just trying to struggle on getting over different benefits and different things that are needed in life. So a few days ago, we talked about why planning was important in general. And then when we're having things like COVID or just recently the tornado and different things, that it just puts everything in jeopardy. Everybody's, if you didn't have your planning, it's very confusing. So that's why we were just kind of looking at this whole roadmap of how everything works. And today, Amanda's going to talk about, or we're both going to talk about this essential legal documents. I do work here at Eamon Gantner Capriano as well. I'm one of the care managers here and then help run the nonprofit. So take it away, Amanda.
All right. Thanks, Gail. As Gail was just talking about, we're sort of doing this series that kind of takes you through a lot of the things that we all need to consider as we think about aging, as we think about planning, whether it's estate planning, long-term care planning, just sort of what do we all need to be considering as we age? What do we all need to be considering once we turn 18, which we'll talk about a little bit today. So last time I sort of did a broad overview of estate planning, but today I really want to talk about if you don't want to estate plan at all, you don't care where your money goes or what happens after you die, that's okay. But today I want to talk about the 5 documents that really everyone over the age of majority, which is 18 in Missouri, everyone should have and why. So this is just a little overview about the firm, Eamon Gantner and Capriano. We do estate planning, elder law, and related matters. By that, I mean we do the post-mortem work as well, so trust administration, probate, that kind of thing. We're all members of the National Academy of Elder Law Attorneys and the American Academy of Estate Planning Attorneys, and we are also all accredited by the VA to handle veterans claims. So here at Eamon Gantner and Capriano, we do a lot of VA benefits, especially aid and attendance benefits for folks. And we'll sort of get into that in one of our later presentations as well. We're going to go a little bit deeper into Medicaid and VA, what that looks like. So stay tuned. This is me. My name is Amanda Wilson. I'm an attorney licensed here in Missouri. I have a BA in English and economics from the University of Mississippi or Ole Miss. And I got my JD from Wake Forest University in Winston-Salem, North Carolina. And I am a member of all of those things I just talked about. And I am accredited by the VA to handle VA claims. This is our elder law department, so it's Gail and I, and then Maggie Burgess, she is our other licensed clinical social worker. So we kind of head up all of the elder law and estate planning that goes on at the firm. So last time we talked about just broad overview, what is estate planning? It's a development of a strategy by which an individual's assets and personal affairs are organized during life and at death. So we'll get into a little bit of wills, trusts, that's kind of what happens to your stuff. But most of these 5 essential legal documents I'm going to talk about are going to be talking about what's happening to you during your life. Um, and it's every bit as important as what happens after you pass away. And it's part of the reason why estate planning and long-term care planning go so closely together.
I think, you know, when I was mentioning about like the tornado and COVID and everything, and you go back and
Mhm.
look at that thing you just had up, it's almost like a tornado thing right there. You know, it's just
Right.
a lot of different pieces. And people think sometimes, well, you know, we talked a little bit the other day about procrastinating, and you procrastinate, you look at this, maybe all these different things, and you hear different things from people, and it's just easier like to procrastinate. Or I've heard people say, man, I'm not sure if you have this, like, well, I won't be here you know,
Right.
I won't be here then. They can worry about it and figure it
Right.
out. Well, we work with so many families here and like, oh my gosh, I have no idea what my parents, you know, did or what. And but the more important part really to me, especially too, and you had just mentioned, is when you're alive. I mean, things happen and you could be in the hospital and not being able to respond to your banking, to your health, to all those kinds of things. And then in the state of Missouri, there's just no way for anybody to take over for you. And so I know you're going to talk about that, but I think that's a super important
No, that's
thing,
exactly right. And we
especially
hear it
when
all
they're
the
you.
time too.
Yeah. Go
We
ahead.
hear, oh, I don't have anything, I don't have any money, so I don't care what happens. And, that's okay. That's, someone's prerogative, but it does matter. You could have 2 pennies to your name and you'll care what happens to you if you get hit by a car and can't make medical decisions for yourself or can't make financial decisions. Um, so a lot of these documents really do matter to absolutely everyone, the $15 million estate holders and people with just their social security coming in and a few $1,000s in the bank. So, and it all kind of works together. I know this picture is overwhelming, but it's all a piece of a bigger puzzle, and it's how you make sure you're protected for what's coming in life, because it happens to all of us. Did you have anything else to add there, Gail? Okay. All right. Failing to plan is planning to fail. It's just the truth of the matter. So if you think about estate planning and you say, oh, it's for later, or you say, I don't know that much about it, so I'm not going to worry about it right now. Or maybe you're just hesitant because you don't like the idea of something happening to you or something happening to your spouse, something happening to your child. And they're really hard conversations to have, but that makes them absolutely no less important. So by failing to make that plan, the only person you're hurting is yourself and your loved ones. It does no good for anybody to avoid those more difficult conversations. Um, Without an estate plan, your loved ones might not know what your wishes are. Maybe they don't know if you want to be buried or cremated. Maybe they don't know if you are in a permanent state of unconsciousness, would you want to be kept alive? A lot of people do. I would argue probably more people would not want to be kept alive in that situation. And I can guarantee you that the hospital medical personnel's reaction is going to be keep you alive unless there are documents in place that are authorizing someone to remove support from you. Uh, Actions your loved ones must take on your behalf will absolutely necessarily be slower. They'll be more complicated for your loved ones to figure out, and it'll cost a whole lot more money than getting these documents in place would cost. So we say this all the time here. You don't create an estate plan for yourself. You do it for the people and the causes you care about. And mostly today, what that means is a lot of times when we're using these documents or they become important to people is at a time when there's a lot of emotional turmoil going on. And it's a really hard time for not only you, but your loved ones. So you really don't want to make that even harder and more complicated by not having a plan in place. Like most things in life, timing is everything. And what I mean by that is too many people wait until it's too late to get these documents in place. We'll have, a married couple who comes in here and the husband will say, well, my wife was diagnosed with dementia 5 years ago. She might be able to tell you what year it is. She probably won't know who the president is. Sometimes she knows who I am, sometimes she doesn't. At that point, if we can make a judgment that the wife has capacity, which is a big if, maybe we can get the documents in place. But it's a whole lot more difficult than had he come in 5 years ago when she was just diagnosed, and she absolutely would have known the year and who he was and where she has a bank account. So it's just the reality that the sooner you do it, the better off you are. And if you want to change, your agents or the documents themselves, not only should you, because the law changes every few years, but there's no problem with changing it. It automatically revokes a previous legal document, and you should do it. But the earlier, the better. So, what documents do you need? I know we've kind of been circling around this, and I'm sort of talking about them all vaguely, but there are 5 documents that you really absolutely need to have. First, we're going to talk about a property power of attorney. So property power of attorney is, or some people call it a financial power of attorney, is a document in which you name an agent, you name someone who would be able to take care of your financial matters during your life if you should need help. Now, technically, there are 2 kinds of powers of attorney. There's a shifting power of attorney and there's a springing power of attorney. Shifting powers of attorney will give your agent authority upon signing. A springing power of attorney would only become effective once you would be judged as incompetent, usually by 1 doctor, 2 doctors, something like that. I'll tell you that in our practice, we always have shifting powers of attorney instead of springing powers of attorney. Because if we're at that point where you're no longer competent, it's so much more difficult and it takes so much longer for you to get that adjudication or determination of incapacity than we want it to. We want your agent to be able to make all those decisions. And honestly, if you're naming someone, you should trust them as much while you're competent as you would once you become incompetent to handle all of those matters anyway. So our financial powers of attorney, we actually have 2 of them. We have a general financial power of attorney, and then we have what's called a special durable power of attorney. That one we only use for real estate matters. So if someone would need to sell your house while you're alive, they could do it with that short form special durable power of attorney. It's only 4 pages. That's because in the state of Missouri, if you're using a power of attorney to sell real estate, it needs to be recorded with the county and they will charge you per page. So we like to have that short one. It saves people about $250 in recording fees. But
I
the
think the
long,
big thing too is because you have to send it in. And a lot of
that's
people,
true
you don't
too.
want to send the original someplace, and so at least you still have your other original, regular power of attorney. And I think, you know, people have a hard time sending the original documents places and trusting you're going to get them back, which generally it seems, I don't think any of them have ever been lost, but it is, a fear.
Oh, it's
And
absolutely a possibility. And the mail gets crazier and crazier every day. So if
yeah.
you can avoid sending an original, avoid it at all costs.
I would just want to go back to your point about trusting people and, working here when I first started, I didn't understand really the difference. I did a POA really quick in the first few weeks, and I think it was, um, the shifting one. And then after probably about a month or so in, I started seeing, I was like, wait, I just need to switch to immediate because if if I'm picking someone and like you said, you trust them or that's the person that's going to take care of stuff, they're not, even because the power of attorney, it's not letting people make decisions for you. You can still make your decisions. It's just allowing them to go to the bank and do it as well. And sometimes people, you're in the hospital or you're sick and you just can't go. And it's not that you're incompetent. And so, but you still need help. And then just getting two doctors a lot of times at that point and that delay, usually if you're in the shape that you need help, you don't need a delay. And so it's not like you can just walk into the bank with the document either. I think maybe back in the day you could, but now they send them off to legal departments and it's a very confusing whether they're going to accept them or not. So having them on file there is so important. And you and I see it every day. These different families, argue and they have a lot of problems. So picking someone that you trust, and if you trust them, I certainly trust people more that I can watch than if I have no idea what's happening.
Right. And some people, I think it's sort of funny, some people get nervous if they name one child as the power of attorney and then have the others as backup and they say, oh, I don't want Susie to get jealous that I named John instead of her. And really it is a lot of work that you're taking on. It's agency and you can handle our general financial powers of attorney are about 40 pages long. I mean, you can gift property, you can open accounts, you can create trust, you can do all kinds of things for the principal, for whoever's power of attorney it is. But with that comes a whole lot of responsibility. And that's the other thing that we hear often is, so Jimmy could just go to the bank and take all of my money. It's like, well, no, first of all, if you're naming him, you should trust him not to do that. But second of all, these powers of attorney, they're agents of you as the principal. And with that comes all kinds of fiduciary obligations. So they have to act in your best interest. They have to do what they think you would want them to do. And if they don't, then, there's recourse with that through the courts. So those are property powers of attorney. That's our first legal document everyone absolutely needs to have. Not all powers of attorney are created equally. So you have your traditional power of attorney. A lot of times they're very brief. I think more and more often these days we're seeing powers of attorney that are drafted by AI, that are drafted through some sort of program online. That's okay. It might do the things you want it to do, it might not. In Missouri, there are all kinds of powers that have to be explicitly enumerated in your power of attorney in order for the power of attorney to have that authority. So, for example, in Missouri, you have to have in the power of attorney that the power of attorney has the authority to make gifts. Otherwise, that person could not gift any of your property. And that becomes super important in the Medicaid and in the long-term care context, because a lot of times we are strategically gifting portions of a person's estate in order to get them qualified for Medicaid. So if you have a power of attorney that is, from ChatGPT or from online, maybe it does some things you want it to, but I'm willing to bet it doesn't do most of what you want it to do. Not to mention, is it even written, in compliance with Missouri law specifically? Is it witnessed properly? Is it notarized properly? So you just need to be really careful with that stuff.
And I think with the gifting, people get in their mind, you can speak to this point, Amanda, about, oh, I can only give so much away per year. And
Mhm.
and then I think you just told me there was an example this week that someone had their power of attorney had that they could only give that certain
Yep.
amount.
Up
And
to that, yeah,
yeah.
annual tax exclusion amount, which is not what we're doing with Medicaid
So
gifting. It's a completely different.
and people confuse that. They think that that tax thing, that's the only thing they can give away. And
Right.
that's not the case. But also when you're going to the bank and putting, like if all of a sudden you need to add a beneficiary designation on the accounts, which you talked about the other day, in the other presentation. They A lot of the banks don't want to allow the POA to do that unless it does say in the document that you could do gifting, because they're considering that a gift after you pass away. So that's an interesting point as
That's
well.
right. Same with resignation of a trustee. If you want your power of attorney to be able to resign you as trustee of your trust, maybe because you're no longer able to handle things and it's really time for you to resign as trustee, that needs to be explicitly mentioned in the power of attorney. I mean, the list is long.
Or even opening an account for you.
Mhm.
So
Yeah,
there's just a lot of different little things that people don't think of. And the bank, and that's what the banks are sticking with when you take it. So
right. And now what if you don't have a good financial power of attorney in place? Your other option is guardianship or conservatorship. And there is nothing easy about it. It is court supervised. It takes a very long time. It's very expensive. So really, if we can avoid that in any way whatsoever, we would like to. So now we'll talk about sort of the other side of power of attorney. Okay. And that is the healthcare power of attorney. So healthcare power of attorney works essentially the same way. You're naming an agent who could make healthcare decisions for you when you're no longer able to make them for yourself. So if you're unconscious, if you're incapacitated, if you are otherwise unable to make your medical decisions. And Missouri is a little bit unique in this area because many states, North Carolina was one, have a statutory backup, which is basically, if you're not able to make your decisions, this person could, then this person could, then this person could, spouse, then a child, that kind of a thing. In Missouri, there's no such statute. So no one is able to make a medical decision for you if you are not able to make it for yourself and you don't have a healthcare power of attorney in place, which is really scary, right? Um, we read a few cases in law school about young women, early 30s, late 20s, who they both got into a car accident and neither had a power of attorney. And after that, their families went through years of litigation because in both cases, the woman's parents were fighting with their spouses about what that woman wanted, whether she would want to be kept. They were both in comas, not expected to come back. Neither had any brain activity. Um,
wasn't one of those a very famous Missouri case?
I think one was Texas and one was Florida, but there might have been a Missouri case too. Again, I went to law school in North Carolina, so we didn't, I didn't get as much Missouri case specific um, examples.
And I think it's interesting because people don't realize this point that you're making, because a lot of times when you're up at the hospital, the spouse is there, maybe the kids or something, and the doctors kind of come in the room, the things are on the board, they just kind of just go with what's happening, and they kind of talk, maybe talk to the spouse, they're trying to talk to the person, and they just kind of give that best care that they can. And so people are assuming that, oh, it is, it's okay because they're doing it. Well, they're not by law supposed to be, and it just depends on which doctor. And it also, if you have the spouse or the kids, if it's the kids and they're disagreeing at all, like there's like a little hint of family friction, they're going to shut that down and be like, we need the guardian. It just depends on really you know, what they're thinking at the time, and they don't have to. But a lot of people just assume because maybe I'm the spouse and I was there and they did this, but it can cause so many issues.
That's right. And it's another super important consideration for young people, right? So we all think, I mean, I know I thought this when I went off to college, I thought, if something happens to me, my mom will take care of it. She's been making decisions for me for my whole life and she'll be able to figure it out for me. And it wasn't until years later that I figured out that once you reach the age of majority, which is 18 in Missouri, your parents can no longer make financial decisions for you or medical decisions for you, absent a healthcare power of attorney or a financial power of attorney. So it's super important to think about when, if you have kids or if you are a young person who's about to sort of enter adulthood, you're right at 18 or maybe in your early 20s, and you might think, it's not going to happen to me, but everyone thinks it's not going to happen to me until it does. And it's really not that big of a deal to get these documents in place, stick them in a drawer, stick them somewhere where other people would know where they are in case of an emergency, and just have them. It's peace of mind. And if you need them, I promise you'll be glad that you had these in place. A few other things that you can designate on a healthcare power of attorney is the right of sepulcher, which is the right to, you can give your healthcare power of attorney the right to move your body, which does not sound like something important, but sometimes is. You have family members who sometimes fight about where the body will be going. So it's a handy authority to determine and to give someone. You can also give them the power to designate someone to act in their place. That can be handy. For example, if your healthcare power of attorney is your oldest son, but he lives in Texas and he is jumping on a flight to get here, but in the meantime, he can designate, okay, my younger sister is going to make these healthcare decisions until I get there, which is super important. You can also designate whether you will be an organ donor or not. A lot of people do want that. A lot of people don't. Entirely up to you, but it's a good thing to decide and to have written down. And there was one more that I wanted to talk about. Oh, you can give your healthcare power of attorney the authority to get an autopsy if they want to know what happened to you, which again, you think, well, that's not that important, or who would want to do an autopsy on me? I'm 86, but you just don't know.
And if you don't have it, all the authority, I think that's what people have to realize too, is that these documents are giving people the authority to do what you could do and what decisions you can make. And once you're deceased, you can't make any decisions. And so that all the authorities stop. And so with this healthcare one, it's giving a few little caveats of designating that people could do these things even though you're deceased. And so if you think about it, that if there's some kind of circumstance that you wanted to have an autopsy, it's probably because you think something went wrong. And if you didn't really have the power and someone is trying to maybe hide that something happened, they're not gonna, they'll be like, oh, great, no one can figure it out, because we're not gonna do that autopsy. So that's like an important fact. Like if they think that somebody dropped you or somebody did this or that and the other and they want to check it out, if the people know that, oh yeah, we kind of screwed up, they're not gonna want to, necessarily do that. So I think that's the important thing, that maybe it's never going to come to pass, but if you wanted to, if you had some suspicion, you're going to have to pay for it too. So you have to kind of decide, is it that important? But it allows you to make that decision. And so I don't know. And
That's right.
yeah. And the other important thing too, I think in here, you kind of alluded to this a little bit with the other document, is being able to pick the people. A lot of times people think, oh, I have to pick the oldest child, or I have to, you were talking about kind of insulting the other kids, or you have to pick two kids. And with the healthcare, really, it's better to have, it is that you should have one person, and you're supposed to only have one person. Isn't that correct for
That's right.
healthcare?
Yeah.
Yeah.
Healthcare has to
Yeah.
be one person.
Yeah, because if you do have two and there's any hint, then the doctors, they don't know what to do. But people should think about, like with healthcare, it's giving the people the right to list, you know, when you're going to look at your other documents, but in terms of, you know, pulling the plug and things like that, you know, like if you're having to make really tough decisions and it's your kids and you know it's the one kid or your spouse and they've already said, well, I could never do that, then that's the person not to not to pick. Or we do have a lot of times that families will pick somebody for the financial that's good with financials, and then they'll pick the other child that's good with doctors. So it's not always the same person either.
Right, we get that very often. That's a good point, is they have, you know, a child that works in the healthcare industry or maybe studied science, something more healthcare related, and maybe they have another person who is better financially. And that's great. Designate who you think would best be able to make those decisions for you and with you in mind. So those are our first two necessary documents: financial power of attorney, healthcare power of attorney. Next is a HIPAA authorization. Um, HIPAA authorizations will allow doctors, medical personnel to tell the people who you designate on the HIPAA authorization form what's going on with you medically. That's super important. It eases a lot of family strain when you are able to give people the information, because it's scary to not know what's going on. And so you want your family members, you know, a lot of people want their spouse to know what's happening to them. A lot of people want their kids to know what's happening to them. If they're no longer able to make medical decisions for themselves, they want other people to know what's happening and really weigh out the best course of action for them. And so that's HIPAA authorization. Sounds pretty easy, but it's a super important thing to have. Our last two documents I kind of put together on this slide, and that's just because they sort of work in conjunction with one another. And those are your advance directives and your living will. So the living will is just a single signature, and it says if two physicians personally examine you and they determine that there is no hope. So if you're in a permanent state of unconsciousness, if you're never getting any better, no matter what the doctors cannot do, if at that point you would no longer wish to remain alive, you would want, like Yael said, if you want the plug pulled, you sign that living will. And I would say the vast majority, I'm not sure I've ever seen someone not sign the living will when we give them the option. I think the vast majority of people would not want to live in that state. And it's completely fine if you would want to be kept alive. That's okay too, you know, but at least you should see the document. You should read the document and say, yes, that's what I would want, or no, it's not.
Yeah. And I've been here 20 years now, Amanda, so I've seen a few people. It is, you know, or well, and I'm not sure if you're going to discuss it, but there's like a lot of items to choose from that you don't want this or you want that, and those get kind of confusing to some people, and so then they'll say, oh, I'll do it later, let me think about that. And of course we've already talked about procrastination, and then they never get back to doing it. Or sometimes, you know, the kids really need, or whoever's the agent needs to be aware of very much so on how their family member felt about it, because I have been in a situation now several times where I had to decide that to not have, you know, that support. And you don't ever want to see the person go, and you feel kind of guilty about it. But on the other hand, if you know that that was their wishes, it makes it a little bit easier for you. It's very difficult, I think, as a child or spouse or anything, to be like, oh, well, I said, yeah, go ahead. But if you knew that's how they felt. So those are difficult conversations, you know, to have in a family.
Right. And I think a lot of times they're conversations that people don't have. And so then it really is good to have it written down somewhere that, yeah, I wouldn't want to be kept alive, because you're just taking some of that sort of autonomous feeling off of the person who's, you know, off of your healthcare power of attorney. It, I think it alleviates a lot of that guilt of, oh my, I'm pulling the plug. And so it's nice to have these directives written down so that people can see, yeah, this is really what she wanted.
It seems
And
like besides just having it written down, at some point having a conversation about it. A lot of
right.
people, they come and they do these documents and they put them in the little notebook and then they take it home and put it on a shelf and they don't really discuss it with their family and the kids have no idea what's happening. And, having that conversation of why you feel that way and what's happening, I think is just as important.
Oh, I think so too. Yeah, that's a good point. Um, so the advanced directive, that's what Gail was talking about, gives you all kinds of options. So the advanced directive actually gives your healthcare power of attorney the authority if you're in the same state we were talking about as with the living will. So if you're in a permanent state of unconsciousness, or if you're at the end stages of a terminal illness, if you're not getting any better, then there are all these situations listed, or treatments listed rather. And by initialing each one, you're allowing your healthcare power of attorney to direct the doctor to either withhold that form of support or not start that form of support. So for example, uh, feeding is on there, nutrition, giving a nutrition is on there. Chemotherapy and radiation are on there. And don't think of it as, well, if I have cancer, I would want chemo or I would want radiation. Probably. If you were at the end stages of an illness, if the chemo or radiation would not make you any better, would you want chemo and radiation? That's the question that the advanced directive is kind of getting at. I would say the vast majority of people will initial every single one and give their healthcare power of attorney the authority. And by initialing these things, the other important thing to think about is you're not saying your healthcare power of attorney has to withhold that treatment. You're just saying your healthcare power of attorney has the ability to tell the doctors, no, that's enough, which is sort of reassuring, right? So you're saying, okay, I'm giving this person that I trust enough to make my healthcare decisions for me the authority to say, okay, she's at the end now. I don't want to give her antibiotics anymore. Maybe I'm in the hospital and I got in a car wreck and I'm in a coma and I end up developing pneumonia. So the pneumonia could kill me, right? The antibiotics won't treat the head trauma from the car accident, the reason I'm in the permanent vegetative state. The antibiotics will treat the pneumonia though. So it could keep me alive, albeit no better off than I was before. And so I might initial that and say, okay, healthcare power of attorney, if I'm in this situation, you have the ability to withhold those antibiotics. I've already said I want to go. Maybe withhold those and let sort of nature take its course.
Yeah.
And these documents get a little confusing for people. I think they think it's worded strangely and it's sort of complicated with layers, right? Because you're giving authority and you're saying yes or no to all kinds of things. But I hope, Gail, was that an okay
Yeah,
explanation?
I think it is. I think the other thing with it is that when you're saying is like everybody then can make that decision. They're making it, you're telling them you can make it, but then they're making it based on the judgment that they're having on what the doctors are saying. And so the doctors are coming and explaining the different things, and then you're then using your judgment based on that. Like, is this really going to help? Is maybe antibiotics isn't the right one for this example, what I was going to say, but if it's going to be something that make them a little more comfortable, maybe you want to keep like with the hydration or nutrition, sometimes it's just a minor amount, but it's keeping them more comfortable, or some of the pain medications, or just different things. Is it going to help in any way with comfort or what have you, but not the longevity, and or maybe sometimes people will say, well, I just, they're feeling bad. Maybe they want their other family to get there or whatever. So they're like, well, I'm not quite ready yet. Because a lot of times the life-saving things get put on because they are going to try to keep you alive. It's after that they figure out, well, it's not really going to help. And so then they're coming. And so, you know, being able to just assess what they're talking about, maybe talking to the other family members, and then just decide, well, this is really not, it's not really what they wanted. And I think when we, are in that position and look at the people and see, and we realize that, hey, that's it's not really what they wanted. And so sometimes it's not like so instant, but you're getting to use your judgment based on hearing the doctors and listening to them and just even looking at your loved one and realizing. But it's giving it on all those different categories so that you're able to decide if it comes down to that. So
The other cool thing about advanced directives too are that if you have specific religious reasons behind some sort of treatment directive that you would like, this is where you can write all of that. So if you're Catholic and you want Catholic last rites administered, we have that in a lot of our documents. Or maybe you don't want to get blood transfusions for religious reasons. You can put that in your advance directive. So there are other things too that if it's really important to you and has to do with your medical treatment in the event that you're not able to voice those beliefs or those desires, this is a great place to put them so that they're respected and honored.
it seems like a lot of people ask questions about that with their religious beliefs and
Mhm.
putting that in. And I think to me, it's too like, and you can correct me if I'm wrong in this, but I feel like the living will is basically more telling your doctors what your intention, where your advance directives, you're telling your agent, this is what I want or not want. And then that way they can, you know, make those informed decisions. And then the doctor's kind of understanding what you want from your living will.
Right,
Right.
that's exactly right.
Okay.
Yep. So those are our 5 documents. And what they give you more than anything is choice and control over, how things are paid for, where you'll receive care, who will provide your care, what kind of care will you be getting. Um, and you can choose when it needs to change. So, like I said before, all of these documents you can replace. It's not like you have to name someone and they have to be your financial power of attorney or your healthcare power of attorney for the rest of time, nor should they be. But really, it's giving you the most flexibility and the most options when you would be in an emergency or an important situation. So let's go over them one more time. You've got your financial power of attorney or your property power of attorney. You've got the healthcare power of attorney, the HIPAA authorization, and then you've got the living will and those advanced treatment directives. Now, important to note, we've spent most of this time talking about these 5 documents. That's because they're the documents everyone absolutely has to have. I would argue that everyone should also have a will or a trust. But is it as pressing to you during your life as these 5 documents are? No. So now I'm just going to talk kind of real briefly overview about wills and trusts. So this is sort of the what happens to your stuff once you pass away. Wills, I think it's a common misconception that a will avoid probate. It does not avoid probate, it directs probate. A will take effect at your death. So the will might say, the will has no power until you pass away, is what I'm getting at there. Um, Wills are a matter of public record. So probate court, it's all public. And we talked about that, I know, a little bit last time, but it's a good point to to bring up again. And the will only govern assets in the probate estate. And what I mean by that is some assets are non-probate assets. So if they have a beneficiary designation on them, a TOD designation, a POD designation, they're non-probate assets. They will avoid probate, unless, of course, you don't have a beneficiary listed or a TOD or a POD on there. Then they become probate assets. And the benefit of a will is it's less expensive and complicated to create. However, on the other side, it's usually, almost always, I would say, more expensive at your death. Probate is super expensive. The fees are also statutorily set. So it's not like us attorneys can charge you an astronomical amount, but it's a statutory fee. So you're going to have to pay it. Okay, so that's your will on the one side. Then you have trusts. Trusts, everything, you think of a trust, right, as a big bucket. And so you get this great trust document drafted, and you have a name for your trust. So let's say it's the Wilson Trust Agreement, right? And that's going to be on the outside of my bucket. By funding my trust, I'm putting assets into it. And then the terms of the trust will dictate where they go, how they go, when they go. So the trust can only control what's inside of it. So only the stuff that's in the bucket will be controlled by the trust. Okay, sort of makes sense. A trust will take effect during life. So as soon as I start putting those assets in the bucket, the trust is the one in control of those assets. So usually the trustee is the manager of the trust, the trustor is the creator of the trust. In the trust terms will control. Trusts cost more in terms of both time and money to create, but they also give you a whole lot more flexibility to determine, not only how much people get, but when they get it, how they get it. If you have, protections for divorce, if you have protections for a child who might have special needs, all kinds of different things. If you have some tax considerations that you'd like to be taken into account, all of that can be sort of thought through and designated in the trust. You can't do the same thing with a will. And trusts are very variable. So no two trusts that we draft here look exactly the same. And that's because the people whose trusts they aren't exactly the same. It's, they have different desires, they have different things that are important to them, and that's okay. That's sort of the beauty of the trust structure. You just get less of that with a will. With our trust plans, we always do a will as well. And that's because, like I was saying before, trust is a bucket. If on the off chance we have an account that doesn't end up in that bucket, it would be a probate asset. We would need a will to direct that probate asset to direct where it goes. So we do what's called a pour over will and say, okay, if we have somehow missed something or you somehow missed something, then we're going to have a will that's going to direct the probate court to send that asset into the trust bucket too. And then it will also be governed exactly the way the trust would be. If you pass away without a trust or a will, what happens is your estate will be designated by the laws of intestacy. So what that means is there's statutory guidelines for who gets what percentage of your estate between your spouse and your kids or your parents or, just depending on your situation. But you have no control whatsoever about that percentage, about how it goes, when it goes, nothing like that. So that's what would happen absent both a will and a trust. They're super important documents. I would argue everyone should have these too, but I really wanted to focus this talk on those 5 legal documents. So powers of attorney, HIPAA, and the advanced directives in the living will, because those are also the ones that are really most important while you're alive. Trusts can be important while you're alive, especially in the long-term care context, but we'll sort of get to that as our series progresses.
And I think, and you kind of you touched on it a little bit the other day, but in terms of the will, that's what directs for minor children,
Oh,
or
yep.
like so. I never even realized it, and I did change it, as my daughter was not a majority when I started to work here, and it's listed as people have their kids listed on their insurance, and there was a kind of horrific case when I first started that um the older adult had changed their beneficiaries, and it was really to their grandkids, and the daughter was unaware at first, and all of a sudden it was to her kids, but then she couldn't even collect the money because she ended up having to get guardianships for those kids because she wasn't bondable. Like she couldn't even be the guardian or get the funds. And so people don't think about it, but the little kids can't inherit they can't take possession of the money. So then you have these insurance companies keeping the money until they're 18. And so another important reason, to have a trust or something where there's some way to get the money, and be able to be using it for the kids, because that poor lady, she was trying to raise those grandkids and she didn't hardly have any money, but because she had to get the guardianship, every single expense had to be approved by the court all the way up until then they were 18. And um, it just was very hard to watch because I kind of knew I had knew the grandma. I kind of knew how she would want. Or I've been involved in cases, case management wise, where you're like, oh, the family wouldn't want them to be homeless, or they wouldn't want these circumstances to be going on. So it's just very important when we're looking at too with all this different things with the COVID and the tragedies and the different deaths, you're not expecting that things happen. So
And very
it's just,
important for people who are much younger than you
mhm.
might think of. When you think of someone who's making an estate plan, a lot of times you think of someone who is a little bit older, who's thinking, okay, maybe long-term care. Maybe you're thinking, but you're also thinking someone who's closer to something possibly happening to them. But anyone who has a child should absolutely have a will in place, probably a will and a trust, because the will is the only instrument by which you can designate a guardian for your child. But the trust is how you want to make sure, if you're going to leave everything to those kids, you want to make sure you know how it's going to be handled. Exactly what Gail was talking
And
about.
like with the guardianship, what you're saying too is that what in the will, if you're designating that person as the guardian, they don't have to be bondable. Like, if there's nobody named and you're just doing it to the court's not gonna decide that that person can be the guardian if they're not bondable. And so maybe you can, speak to that for a second, because um people might not be aware of what that's meaning, but yeah, or somebody else, the court could pick someone totally different
Right.
than you wanted to take care of your children. And that's like, very close to our heart. We want them to be raised in a certain way.
Right. And simply, you want to be the person who decides who is taking care of your children. You don't
Mhm.
want the court. If you would pass away with a minor child without a will, or with a will that does not specify a guardian for that child, then the court is going to end up determining who is in charge of that child. And there might not be someone available, right, who the court is comfortable leaving your minor children with. So then the court will pick someone, whether it's someone you knew in life or maybe it's not someone you knew in life. And the court will have requirements of those people. So maybe you have a brother who has, the best heart and he's the best with your kids and he would do anything for them. And you have a fair amount of money, so you're not worried about, if something happened to you, your money would take care of your kids. But you want him to be the person whose house they go and live at, and you want him to be the person who's in charge of sort of doling out those funds to your children. Well, then you need to designate that.
And I think this has
That's
come
all.
up here before, Amanda, maybe in discussion, maybe you can clarify this if I'm off base with it, but if you don't have that in place and there's like an emergency, sometimes they end up, there's no one can really take physical custody right at that moment either. So that's how sometimes they end up in like a foster care at first,
Right.
because then someone has to apply to be the guardianship because there's nobody, you just don't happen to have that, it's like, a babysitter has them, something happens, then that someone's coming in and taking them until the court can determine
Right. It's the
sometimes.
state who's responsible in that situation. So it's, the Department of Family Services that will provide your children care until those determinations can be made. And I can think of no one who that would be their first choice for their child in
Mhm.
those
And
circumstances.
and we just tend to like you just pointed out, usually a lot of times it's the older person, coming in to do that planning because they're looking at, oh, I'm getting closer to the end, and so I better plan. But just from the beginning, it's an important thing. And a lot of people procrastinate for all kinds of reasons, but when they're young, they don't think it's going to happen to them right then. But also, financially, they think, oh, well, I can't afford it. Well, you need to find some way to afford it because you just the battle of the guardianships. I mean, if your mandatory guardianship is costs a lot more than just doing a paper.
A will plan. That's right.
Mhm.
Okay. So what's next? Our next presentation is going to be next Tuesday on October 21st. It's going to be same time, 11 a.m. And Gail and I will be talking about care management and choosing care. So we're sort of switching back to long-term care realm, right?
Mhm.
Um,
And kind of and you think, well, the legal stuff doesn't fit in there, but it does. Like it's all that's why we have actually three licensed social workers, here at the law firm because it's all pretty intertwined.
oh yeah, yeah, absolutely. And we'll talk about that more as we kind of go along, but it really ties our hands if people don't have these documents we talked about today in place. And they're looking for long-term care. It just does. So, and we'll talk about that more.
And,
Okay.
and I've had situations where it's even with spouses and they're trying to get their spouse in someplace and then they don't have any documents and they have memory loss, which is one of our things that we're going to talk about on dementia. Then all of a sudden I've had the spouse have to go and do a guardianship, for them to get them in a facility. And yeah, it's just a really hard situation.
Oh, and it's making a hard situation exponentially worse. That's
Mhm.
that's the worst thing about it, right? Is that
Right.
these people are already in terrible times and it just
Mhm.
makes it harder. So
Yeah.
we can't emphasize enough how important these are.
Yeah, and I've been contacted by care managers at the hospital, and it's like it's time for them to move somewhere, but no, but the person can't express what's really happening with them, like what their finances were, that nobody knows anything, and there's not doesn't seem to be any family member, and all of a sudden the hospital's in this position to try to do some type of guardianship thing just so that they can figure it out and get them out. In the meantime, they're sitting there in the hospital for weeks, at a time when they shouldn't be there.
Right.
So
All right. Did we get any questions or
I don't see anything. I think you're very thorough, so there isn't. But people, you can put questions in the comments on Facebook, and for the future, where we watch and we can answer them. And if anybody has questions too, they can reach out to Amanda here at the law firm, and she'd be happy to answer. And there's the email. And we are happy for anybody that wants to have an appointment or a question to to really reach out and get that. And if you have any too, you can reach us at Aging Advantage and we're able to help you with your care concerns. I think
Thank
that's,
you.
yeah.
We'll see you guys next time.